This course is Introduction to Philippine Criminal Justice System.
Hello, this is still me and you are on your midterms already. You are halfway to finish this course. Keep going!
We are on the Module 3. We are already in our second lesson, the lawyer of the state, prosecution. In this lesson, you will understand what does the prosecution pillar in our criminal justice system, as well as you will determine who is a prosecutor and what are their functions. Also, you will meet the terminologies related to prosecution in order to have a depth understanding of the said pillar and understand the prosecution process applies in the criminal justice system in the country.
At the end of the lesson, you should be able to identify the functions of a prosecutor, explain the terms related to the prosecution in the Philippine criminal justice system, and analyze the prosecution process in the Philippine criminal justice system.
In all our lessons, I have some few reminders. First, you need to stay focused. Listen to the lesson and understand what is the lecture all about. The second reminder is, you need to have your pen, paper, and module ready. Because one of the most effective ways in order to grasp knowledge is to take down notes. I am not telling you to write it all down, but you need to focus on the main idea, as well as it will serve as an aid in reviewing your lessons. And the third reminder is, if you have any questions, you can post it in our group or in our educational platform. These are all the contents of the presentation. It has the lesson, learning objectives, the discussion, learning activity, learning assessment, and learning sources.
Ready now? Click the button and let us begin. The second pillar is the prosecution arm of the government. It is mandated to uphold the rule of law, and it is the stage at the prosecutor evaluates the findings of the police to determine if prosecution of the suspect in court is warranted. The National Prosecution Service is the prosecution arm of the government. The NPS, which is under the supervision and control of the Department of Justice, runs a nationwide organization consisting of state prosecutors, provincial prosecutors, and city or municipal prosecutors, tasked to undertake the investigation and prosecution of cases involving violation of penal and special laws. The NPS is mandated to maintain and upholds the rule of law through effective, expeditious delivery of prosecutorial services in order to enhance peace and order. The members of the NPS are primarily tasked to investigate and prosecute all criminal offenses defined and penalized under the Revised Penal Code and other special penal laws. They perform two types of prosecutorial powers, investigatory and prosecutor, such as they evaluate the police findings referred to them or other complaints filed directly with them by individual persons. For example, government officers in charge of enforcement of law violated. They also need to file corresponding information of criminal complaints in the proper courts on the basis of their evaluation of the proofs at hand and prosecute the alleged offenders in court in the name of the people of the Philippines. So we have here persons that are part of the criminal justice system, and we have attorneys in private practice. They should be deemed a part of the CJS component, especially in prosecution, because they represent the parties. What are the two parties? The complainant and the respondent. Pag sinabi natin complainant, sila yung nagko-complain. Pag sinabi natin respondent, yun yung ikino-complain. So they're going to represent either of the party in proceedings before the public prosecutors. So also not just private practice, but we also have public defenders such as members of the PAO and other legal aid lawyers. For the prosecutor, They serve as the lawyer of the state or the lawyer of the government in criminal cases. The prosecutor is automatically considered an officer of the court at the same time. So he is an officer of the prosecution as well as he is also an officer of the court. So he is formally a member of the Department of Justice under the executive branch of the government and thus independent from the judiciary. Now, prosecutorial discretion typically enters the picture immediately after the arrest when the police investigative reports are forwarded to the prosecutor for review. The prosecutor screens and evaluates the document in order to decide whether to accept or reject the case for prosecution. The action of the prosecution is dependent upon the police initiatory action whereby the criminal justice system relies on the certainty of the arrest by the police, certainty of conviction by an effective prosecution, certainty of appropriate sentencing by the court. So, if the investigating fiscal or the prosecutor finds cause to hold the respondent for trial, he shall prepare the resolution and corresponding information. He shall certify under oath that he, or as shown by record, an authorized officer, has personally examined the complainant and his witnesses, that there is reasonable ground to believe that a crime has been committed and that the accused is probably guilty thereof, that the accused was informed of the complaint and the evidence submitted against him, and that he was given an opportunity to submit controverting evidence. Otherwise, he shall recommend dismissal of the complaint. In either case, he shall forward the records of the case, including the resolution, to the provincial or city fiscal or chief state prosecutor within 5 days from his resolution. The latter shall take appropriate action thereon within 10 days from receipt thereof, immediately informing the parties of said action. No complaint or information may be filed or dismissed by an investigating fiscal without the prior written authority or approval of the provincial or city fiscal or chief state prosecutor. Where the investigating assistant fiscal recommends the dismissal of the case but his findings are reversed by the provincial or city fiscal or chief state prosecutor on the ground that a probable cause exists, the latter may, by himself, file the corresponding information against the respondent or direct any other assistant fiscal or state prosecutor to do so, without conducting another preliminary investigation. If upon petition by a proper party, the Secretary of Justice reversed the resolution of the provincial or city fiscal or chief state prosecutor, he shall direct the fiscal concerned to file the corresponding information without conducting another preliminary investigation or to dismiss or move for dismissal of the complaint or information. And that is under the Section 4 of Rule 112. But in cases involving public officers, police, and the military, prosecutors are required to forward the resolution to the Office of the Ombudsman. Tandaan ha, if the case is ang involved natin ay police or any military person, military official, okay, i-forward yung resolution to the Office of the Ombudsman for military and other law enforcement offices. The Ombudsman has the power to either endorse or to reverse the prosecutor's resolution, and that is according to the Joint Circular with DOJ Circular 1, 1995. If the Ombudsman decides to endorse the filing of charges, the Ombudsman also has responsibility to appoint or deputize a prosecutor to take charge of the case. However, in practice, public prosecutors are automatically treated as deputized. There are no specialized prosecutors working for the Ombudsman on cases involving officials. This creates problems because sometimes a prosecutor who has resolved that a complaint against the military be dismissed is later deputized to prosecute the case. That the same prosecutor is called to resolve a case and then prosecute it contrary to the resolution is a consequence of the shortage of prosecutors.
For the role of the prosecutor, there is an additional video posted in your learning management system.
Now, for us to be able to understand more about the prosecution pillar, let us discuss the terms related to it. So the first one is complaint. A complaint is a certain written statement charging a person with an offense subscribed by the offended party, any peace officer, or other public officer charged with enforcement of the law violated. So when you want to bring someone to the judicial process, we start by filing a criminal complaint. Okay, so kapag may gusto tayong ireklamo, umpisahan natin sa paggagawa ng complaint. So, a complaint can be filed by any citizen or law enforcement officer such as the police, or if the complaint is against state agents. We have the Commission on Human Rights. So, citizens who have a reliable lawyer can prepare their own complaint and file it straight before government prosecutors. Others go to the police, which will conduct an initial investigation and prepare the complaint on behalf of the citizen. Others go to the National Bureau of Investigation, which will do the same thing. So the police or the NBI or the CHR will then file the complaint before the government prosecutors. The second term is information. So an information is an accused or accusation in writing charging a person with an offense subscribed by the prosecutor and filed with the court. So, para siyang pareho. Papansin mo, complaint and information is parang pareho. Pero hindi. Ang complaint ay fina-file ng isang tao. Pwedeng ako, example, isa akong ordinary citizen. Pwede ko siyang i-file. Okay? Saan ako madalas nagpa-file? Madalas ako nagpa-file sa police station, di ba? Pag may gusto kong ireklamo, madalas pupunta ako sa police station. So, magpa-file ako ng complaint and then tutulungan ako ng police para gumawa ng complaint. Yun yung nabanggit natin nung una, na yung police ngayon ay mag-iimbestiga kung meron bang sapat na ground yung aking complaint para ituloy sa kaso. Ang information naman ay fina-file ng prosecutor. Tandaan, prosecutor lamang. So, kapag, example, ako, citizen, and then ipa-file ko yon sa police station. Gagawa kami ng complaint. Yung complaint na yun, kapag nakita ng police na merong ground, na meron talagang krimen, yung complaint ibibigay niya sa prosecution pillar, sa prosecutor. Ngayon, si prosecution, dahil gagawa siya ulit ng investigation, titignan niya kung yung complaint ay may sapat na basihan. At kapag nakita niya na yung complaint ay may sapat na basihan, na meron talagang krimen at dapat merong managot, ngayon, yung complaint magiging information. So, from complaint to information. Yung information ngayon, yun yung ipapasa niya sa korte. Okay. Sino ba ang pwedeng mag-file ng information? Ang pwedeng mag-file ng information ay ang prosecutor lamang. Sila lang yung may karapatang mag-file ng information sa korte. Ma'am, pwede ba yung magko-complaint ako sa police diretso sa korte? Hindi. Okay? Kasi titignan pa yan ng prosecution kung yung complaint mo ay merong sapat na basihan. Kasi kapag wala, o di hindi matutuloy yung kaso. Pero kapag meron, yung complaint, magiging information, sa prosecution, yung information ipapasa niya ngayon sa court pillar. So, the complaint or information shall be in writing in the name of the people of the Philippines and against all persons who appear to be responsible for the offense involved. So, the elements of complaint and information are just the same. We have the name of the accused, the designation of the offense committed, the act or omission complained of, the name of the offended party, the approximate time of the commission of the offense, and the place where the offense was committed. Next, we have prosecutors. Government prosecutors are the city, provincial, and regional prosecutors, and the state prosecutors. So, state prosecutors are those with the Department of Justice or the Office of the Ombudsman. If the complaint is against a private citizen, it is filed before city prosecutors or the prosecutors of the DOJ. If the complaint is an offense covered by anti-graft court, so Sandigan Bayan, criminal and civil cases involving graft and corrupt practices and such other offenses committed by public officers, tandaan public officers and employees, including those in government-owned or controlled corporations in relation to their office, then it is filed before prosecutors of the Office of the Ombudsman. So tandaan, if the accused o yung gusto nating ireklamo ay isang private individual, then i-file natin yung complaint, ibibigay natin yan sa city prosecutor. Pero kapag public employee or public official, okay, or government official, ipa-file natin yun sa Office of the Ombudsman. The next term is inquest. So, inquest is a proceeding done by prosecutors when the person was arrested without a warrant. So, a warrantless arrest is allowed under conditions set by the rules of the criminal procedure. So, na-discuss na natin yan nung nakaraan, na sinasabi natin na pwedeng mag-aresto kahit wala kang warrant of arrest. So, yung mga na-aresto nang walang warrant of arrest, idinadaan sila sa inquest. Ano nga ulit yung mga instances where we can arrest a person without warrant of arrest? That is when the person commits the crime in the presence of the officer, or when there is a probable cause to believe a crime has just been committed, or if it is a prisoner escaping from jail, or if the offense is continuing offense, like rebellion. So, inquest proceedings are also used to determine if there is probable cause to indict the person. When a person is lawfully arrested without a warrant involving an offense which requires a preliminary investigation, the complaint or information may be filed by a prosecutor without need of such investigation, provided an inquest has been conducted in accordance with existing rules, and in the absence or unavailability of an inquest prosecutor, the complaint may be filed by the offended party or a peace officer directly with the proper court on the basis of the affidavit of the offended party or arresting officer or person. So, before the complaint or information is filed, the person arrested may ask for a preliminary investigation in accordance with this rule. But he must sign a waiver of the provision of Article 125 of the Revised Penal Code as amended in the presence of his counsel. Notwithstanding the waiver, he may apply for bail, and the investigation must be terminated within 15 days from its inception. After the filing of the complaint or information in court without a preliminary investigation, the accused may, within 5 days from the time he learns of its filing, ask for a preliminary investigation with the same right to adduce evidence in his defense as provided in this rule. So, how should the complaint or information be filed when the accused is lawfully arrested without warrant? So, the complaint or information may be filed by a prosecutor without need for a preliminary investigation, provided an inquest proceeding has been conducted in accordance with the existing rules. That is according to the Section 6, Rule 112 of the Rules of Court. Question. Suppose there is no inquest prosecutor, or there is an inquest prosecutor but he is not available. What will happen now to the case? So, in the absence of an inquest prosecutor, the offended party or any peace officer may file the complaint directly in court on the basis of the affidavit of the offended party or peace officer. So, what is the remedy of the person arrested without warrant if he wants a preliminary investigation? So, before the complaint or information is filed, he may ask for one, provided that he signs a waiver of his rights under Article 125 of the Revised Penal Code in the presence of his counsel. He may still apply for bail in spite of the waiver. The investigation must be terminated within 15 days, and we need to correlate this with Section 2 of the RA 7438, which is the law protecting rights of the persons under custody. For example, he must be assisted by his counsel, otherwise the waiver is not valid. After the complaint or information is filed, but before the arraignment, the accused may, within 5 days from the time he learns of its filing, ask for a preliminary investigation. So the request for a preliminary investigation should be made before plea. Otherwise, the right to ask for a preliminary investigation shall be deemed waived. The period for filing a motion for a preliminary investigation after an information has been filed against an accused who was arrested without a warrant has been characterized as mandatory by the court. So, in People v. Figueroa, the Supreme Court held that as the accused in the case did not exercise his right within the 5-day period, his motion for the investigation was denied. What are the guidelines to safeguard the rights of an accused who has been arrested without a warrant? So first, the arresting officer must bring the arrestee before the inquest prosecutor to determine whether the person should remain in custody and in charge in court, or if he should be released for lack of evidence or for further investigation. Number 2, the custodial investigation report shall be reduced to writing, and before such report is signed or thumb marked, if the person arrested or detained does not know how to read and write, it shall be read and adequately explained to him by his counsel or by the assisting counsel provided by the investigating officer in the language or dialect known to him. So for example, ang alam lang niya ay Pangasinan na salita or Ilocano, yung ganun. So dapat i-explain sa kanya sa lengguwahe or sa dialekto na naiintindihan ng taong yun. Kasi ibig sabihin, kapag example, nasa English, at yung taong yun ay hindi marunong mag-English, hindi marunong magbasa, magsulat, tapos pumirma siya. So, ibig sabihin, parang invalid yun. Kasi nga, hindi niya naiintindihan yung dapat niyang malaman. So, kailangan i-explain sa kanya sa dialect or language na naiintindihan niya. Otherwise, such investigation report shall be null and void and of no effect whatsoever. So, magiging walang bisa yung report na yun. Kasi nga, in the first place, hindi niya naiintindihan yung kanyang pinirmahan o sinamarkan. So that is based according to DOJ Circular number 61. Now for the next term, we have preliminary investigation. I guess we mentioned this quite times. We have the preliminary investigation, which means that is an inquiry or proceeding for the purpose of determining whether there is sufficient ground to engender a well-founded belief that a crime cognizable by the regional trial court has been committed and that the respondent is probably guilty thereof and be held for trial. So that is according to the Section 1, Rule 112. Ganito yan. Ang preliminary investigation ay investigation na tinitignan kung meron bang sapat na basehan yung complaint. Anong hinahanap sa preliminary investigation? Ang hinahanap doon ay yung probable cause. Ano yung probable cause? Ang probable cause ay isang paniniwala na merong krimen nangyari at merong dapat managot. Okay? Ang preliminary investigation ay ginagawa ng prosecutor. And that is aside from the initial investigation or investigation conducted by the law enforcement. As basis in charging or prosecuting person with an foreign offense, probable cause is the existence of such facts and circumstances as would exile the belief in a reasonable mind, acting on the facts within the knowledge of the prosecutor, that the person charged was guilty of the crime for which he was prosecuted. So, also, probable cause is a ground for an arrest or issuance of a warrant of arrest. Probable cause is such facts and circumstances which would lead a reasonably discreet and prudent man to believe that the person sought to be arrested has committed an offense. Probable cause is the knowledge of facts, actual or apparent strong enough to justify a reasonable man in the belief that he was lawful grounds for arresting the accused. Now, since preliminary investigation is under the prosecution pillar, who are the officers who are allowed or empowered to conduct preliminary investigation? So we have judges of the municipal trial court. We also have judges of the municipal circuit trial court, national and regional state prosecutors, provincial or city prosecutors, and such other officials that may be authorized by law like the Tanod Bayan, Comelec lawyers, and the municipal mayor in the absence of the municipal judge. So the purposes and objectives of preliminary investigation are to protect the innocent against hasty, oppressive, and malicious prosecution, to secure the innocent from an open and public accusation of trial, from the trouble, expense, and anxiety of public trial, and to protect the state from useless and expensive trials. So again, the preliminary investigation can be conducted by those officers. So they can see or they can decide if the complaint has probable cause. Paramount to the prosecutor's role is to establish at initial stages that a probable cause exists that a crime has been committed. This requires close coordination with investigating agencies. For example, we have the PNP, the NBI, and we also have the quasi-judicial bodies empowered to conduct investigation. So, where a prosecutor finds probable cause, the respondent, yung inireklamo, or yung suspect, since nasa prosecution pillar na siya, respondent na ang tawag, the respondent must be informed of the case. This is done by way of a subpoena or formal notice, giving the respondent an opportunity to reply to the allegation within 10 working days from the time of receipt of the notice, unless an extension is sought. In practice, respondents often are not notified that a case is pending against them. They may not receive the notice or subpoena, particularly if living in a remote area. So failure to submit a reply means that the respondent has waived his right, and the prosecutor may resolve the complaint based on the documents and evidence they have on hand. The prosecutor resolves the complaint by writing a resolution which contains findings on whether or not a criminal offense has been committed and on which, if any, charges should be filed in court. The prosecutor may decide whether or not to call both parties to appear for preliminary investigation or summary hearing. The purpose of a summary hearing is to stipulate the facts and confirm the accuracy of the information before going to trial. For instance, the name and identity of the accused in order to prevent wrongful prosecution. So it does not consider the merit of the complaint or the substance of the allegation. In writing the resolution, the prosecutor decides either to dismiss or endorse the filing of formal charges for trial. If dismissing the complaint, the resolution should contain an argument finding no probable cause. If the filing of formal charges is recommended, the resolution must convince a supervising prosecutor that there is a probable cause and that there are grounds for a well-founded belief that a crime has been committed. Only then are charges filed in court. If the offense is punishable by jail time of at least 4 years, 2 months, and 1 day, the complaint is required to undergo a preliminary investigation. In the event that the person is arrested without warrant and the offense is required to undergo, anong kailangan? Inquest proceeding. We also have other terms such as indictment. So after inquest or preliminary investigation by prosecutors, they will issue a resolution which contains the findings. Prosecutors will either dismiss the complaint or find probable cause to file charges against a person. If there is probable cause, then that person is indicted. So when a person is indicted, it does not mean that he or she is charged. Only when the prosecutors file the information before a court is a person considered charged, or in Filipino, kinasuhan. An indictment can still be appealed by the accused or by the complainant. With Aquino, for example, he has appealed his indictment for graft over the Mama Sapano operation in 2015. The complainants also appealed the indictment, wanting Aquino to be indicted for homicide and not for graft. So when we talk about charge, a person is considered charged when the prosecutors finally file the information before a court. There are instances when prosecutors withdraw information they have already filed in court. For example, Superintendent Marvin Marcos and other policemen were already charged with murder over the killing of Albuera, Leyte Mayor Rolando Espinosa Sr. In fact, by City Leyte Regional Trial Court, Branch 14 already issued warrants of arrest against them last March. But in April, Marcos and the company filed a petition for review, which became the basis why a separate DOJ panel, headed by an undersecretary and not a prosecutor, downgraded the indictment from murder to homicide. So, in Undersecretary Renante Orcio's resolution, provincial prosecutors were ordered to withdraw the murder charges from the Baybay City Regional Trial Court and amend the information to homicide. Senator Panfilo Lacson questioned Orcio's authority to handle the petition for review, instead of the usual process of prosecutors handling such petitions. The warrant of arrest is the next term. So as soon as the information is filed, the accused can begin filing motions and pleadings. At this point, trial court judges or justices will determine whether there is probable cause to issue a warrant of arrest. This issue is being contested in the case of detained Senator Laila de Lima. De Lima's camp believes Muntinlupa Regional Trial Court Branch 204, Judge Juanita Guerrero committed grave abuse of discretion by ordering her arrest, saying that Guerrero did not give due process to her motion, questioning the trial court's jurisdiction. De Lima elevated the case to the Supreme Court. Sometimes the court will decide there is no probable cause to issue a warrant of arrest and dismiss the case that early. This is what happened to the plunder case against the former Department of Agriculture Undersecretary Jocelyn Jokjok Bolante over the fertilizer fund scam. The Sandigan Bayan acquitted Bolante even before issuing a warrant of arrest. The Office of the Ombudsman is also appealing this before the Supreme Court. The next term is arraignment. It is the legal mechanism whereby an accused is brought before the court wherein the complaint or charge against him is read by the clerk of court in the presence of the lawyer and the prosecutor, in which the accused is to announce his plea. This is where the accused enters his or her plea. When the accused refuses to enter a plea, the court is required to enter a not guilty plea on his or her behalf. Under the rules, an accused can only file a motion to quash before entering a plea or before arraignment. That is why Binay heavily contested his conditional arraignment last May for the previous years for his earlier graft cases over the irregularities in the construction of the Makati City Hall parking building. His latest indictment was for the irregularities in the construction of the Makati Science High School. Binay wanted to travel with his family to Israel, but he was not arraigned at the time. For the court to attain jurisdiction over him and be able to issue a travel grant, they had to arraign him. So Binay fought hard to amend his conditional arraignment because his lawyers did not want to lose legal options. So the Sandigan Bayan ruled, however, that the conditions of his arraignment still allow Binay to file a motion to quash. He was eventually arraigned for graft, his first ever for a corruption case. So the next term is trial. Trial, after subjecting the case to pre-trial proceedings, where the accused can attempt to have the charges dismissed through different motions. The court will decide to move to trial. So generally, when the case is already on trial, the next chance that the accused can move to dismiss is to file a demurrer of evidence after the prosecution rests its case or after they are done presenting their evidence. Presentation may take a while, so some accused try to prevent or delay their case from reaching trial. For example, the plunder case against former Senator Juan Ponce Enrile is still in the pre-trial level because the court still needs to resolve pleadings filed by the Enrile camp. In its latest resolution in April for the previous year, however, the court junked Enrile's motion dismissed the charges. So the judicial process indeed takes a long time. So accused individuals have the constitutional right to a speedy disposition of cases, and they avail of this option especially in corruption cases. That is why some graft cases are dismissed due to what is now known as inordinate delay. The Office of the Ombudsman is usually the subject of this appeal, with defendants saying prosecutors took too long investigating. The Office of the Ombudsman or the Ombudsman has challenged this doctrine before the Supreme Court. The prosecution process starts the moment the law enforcer, the complainant or public officer in charge of the enforcement of the law alleged to have been violated files a case against a suspected criminal. With such filing, preliminary investigation will set in and the second stage in the life of a criminal action is now in progress. The first stage is the police investigation. A preliminary investigation is an important substantive right of persons suspected of crimes, the deprivation of which is tantamount to a deprivation of due process of law. It is designed against hasty and malicious prosecutions. So, preliminary investigations may be conducted by the public prosecutors or judges of the municipal circuit trial courts, in which we have mentioned a while back. So, the procedure in the conduct of a preliminary investigation are as follows. we have the filing of complaint and affidavits of witnesses by the police, complainant, or public officer in charge of the enforcement of the law alleged to have been violated. We also have personal examination of affiants by the investigating prosecutor, preliminary action by investigating prosecutor, and the preparation of a resolution based on the evidence presented, the investigating prosecutor may find. However, in both cases, the approval of the provincial or city prosecutor or the chief state prosecutor recommendation is necessary, and as regards offenses within the jurisdiction of the municipal trial courts, no preliminary investigation is required by law. All that the public prosecutor is required to do is to examine the complaint and supporting affidavit, and to personally satisfy himself that the affiants voluntarily executed and understood their affidavits and that the suspect has probably committed the offense charged. This examination and determination he does ex parte, example, without notice to and in the absence of the suspect. He then files the information directly with the court. At the preliminary investigation of a crime cognizable by a regional trial court, the respondent has the following rights: to have notice of the investigation and to have a copy of the complaint, affidavits, and other supporting documents. To submit a counter affidavit and other supporting documents within 10 days from notice. To examine all other evidence submitted by the complainant. To be afforded an opportunity to be present at any hearing at which clarification of certain matters is to be made, and submit questions to the investigating officer for the purpose. It bears emphasis that aside from a preliminary investigation, there is another type of investigation which a prosecutor may conduct, and that is what we call inquest investigation. We already discussed that a while back. So, inquest investigation is an informal and summary investigation conducted by a public prosecutor in criminal cases involving persons arrested and detained without the benefit of warrant of arrest. So, sila yung mga inaresto ng walang warrant of arrest. So, dadaan sila ng inquest proceeding. A respondent against whom an adverse resolution was issued by the investigating prosecutor is not without any remedy. He may file an appeal to the Secretary of Justice within 15 days from receipt of the questioned resolution. If the preliminary investigation results in the finding that a crime has been committed and the suspect is probably guilty thereof, the public prosecutor will be filed the corresponding information in the proper court, thus activating the judicial process. The case shall then be set for arraignment, which is the first stage of a criminal action. It consists of the reading of the information or criminal complaint in court to the accused in open court. The accused is then asked how he pleads. The accused may plead guilty or not guilty to the offense charged. If he refuses to plead, a plea of not guilty will be entered for him. If the accused pleads guilty, the court shall sentence him to the corresponding penalty if it satisfied of the voluntariness of the plea, and otherwise of the guilt of the accused. If the accused pleads not guilty, the case is set for pre-trial and or trial. The pre-trial shall consider the following matters: plea bargaining, stipulation of facts, marking for identification of evidence of the parties, waiver of objections to admissibility of evidence, and such other matters as will promote a fair and expeditious trial. No agreement or admission during the pre-trial shall be used in evidence against the accused unless reduced in writing and signed by him and his counsel. After the pre-trial stage, trial follows. The prosecution commences the presentation of evidence, followed by the accused. Prosecution may present rebuttal evidence, and the parties may also present written arguments or memoranda, after which the case is deemed submitted for decision. After the reception of the contending parties' pieces of evidence, the case is now submitted for decision, which the court must render within 90 days after trial. If the court acquits the accused because in its view he is innocent or his guilt is not proven beyond reasonable doubt, the case is definitely ended. Appeal by the prosecution is barred by the principle of double jeopardy. On the other hand, if it convicts the accused because in its view his guilt of the crime charge has been established beyond reasonable doubt, the latter may move for a new trial or reconsideration.
And that is the end of our discussion. Let's proceed to the learning activity. Your assignment will serve as your learning activity. Your assignment for this lesson is posted in your learning management system. Your learning assessment is the quiz posted in your learning management system. For the references used in the lesson, these are my sources. For the graphics or pictures used in this presentation, these are the internet sources.